Good morning and welcome to Optima Healthcare Insurance Services webinar, Elder Abuse, Reducing Risk on Rising Trends. I'm Millie Mastromati with Optima Healthcare Insurance Services and your program moderator today. Last September at the CHI board meeting, a discussion arose about the increase in elder abuse allegations in hospital litigation. And this webinar and accompanying ECRI leadership tool are a result of the CHI board request to offer risk mitigation education and resources to you. So we hope you find this valuable today and get all of your questions answered. Our speaker, Brian Reed, is a partner in the San Bernardino office of the Lewis Brisbois Law Firm and vice chair of their long-term care and elder law practice. Mr. Reed's civil trial practice focuses on the defense of nursing homes, assisted living facilities, physicians, hospitals, and other healthcare and long-term care professionals and organizations. He has recognized expertise in all aspects of nursing home and medical malpractice litigation, with a strong reputation for obtaining successful results for his clients through law in motion, mediation, arbitration, and trial. Brian, we're so happy that you could be with us today. Welcome.
All right, it's my pleasure. Thank you very much for asking me to participate. I'm very honored. You all provide amazing services to our community, and it's really a blessing for me to be able to work with all of you, and I'm happy to do anything I can to help you do your job better or easier, whatever I can do and whatever we can do. So we have a lot of slides, and I'm covering a broad spectrum. I believe we have participants from everywhere from acute to AL, RCFE, and I think what I'll be saying, it will be applicable to everyone, understanding that you know, the board's focus is hospital, but there's such a broad overlap. I think I'm hoping it'll be useful to everyone. And with that said, I recognize that in our acute care setting, we work with patients. In our skilled nursing setting, we work with residents. AL, we call them just about anything, usually residents. So I'll probably be using those words interchangeably, but I do understand that we have different terminology at you know, at the various levels of care. All right, so let's push ahead. Lots to cover. I thought it would be really helpful just to talk about what it is we're talking about and what it's not. My background is for the first probably 10 years of my career, I was a med-mal defense lawyer. I mean, true and true, that's all I did. Tried a lot of cases. You know, Micra was my right arm, and so I very much understand, and I continue to do med-mal cases to this day. I understand the dynamics of those cases and what you all deal with when you get sued for medical malpractice. Of course, it's you know, standard of care, perfection not required, and we have that nice protection of Micra. We also would see wrongful death claims, which remember, the wrongful death claim, the malpractice claim is brought on behalf of a living plaintiff. The wrongful death claim is brought on behalf of the heirs if someone's passed away. Micra, when it's a wrongful death claim against a healthcare provider, which our RCFE ALs are not, so that's a carve out. Of course, Micra applies there as well. What we're talking about today is elder abuse. It's a very different claim. I guess if there's a theme to this presentation, it's that. Elder abuse is different. And with that appreciation, just understanding that, I think you're going to be able to process these claims, if these causes of action, should they pass across your desk. And we'll talk about why they're different and how we address them. Note that in elder abuse, I wrote that it's a claim on behalf of the resident or the patient, living or dead, all right? And where we really get into, so the reason that the elder abuse is important is because under the the hallmark case of Delaney versus Baker. It's the California Supreme Court case that first interpreted elder abuse probably 15 years ago now. The California Supreme Court said what I just said. Elder abuse is different. Elder abuse is not professional negligence. Therefore, MICRA does not apply when elder abuse is proven, okay? So one of the things we do in litigation is we argue whether the plaintiff is going to prove elder abuse. If they prove it, MICRA won't apply. If they don't prove it, it will apply for all of you healthcare providers. Elder abuse was designed, it's a statutory claim, and it was designed by the legislature to encourage the rights of the elderly and dependent adults to be prosecuted. Before elder abuse, there was a perception that the cases just didn't have value, and so plaintiffs' lawyers, the legislature says, we want you to take up these claims. Well, in my world, where now I do a tremendous amount of long-term care, elder abuse defense, probably 60-70% of my practice, at times 90%, well, it certainly had that effect. So we'll move on. Elder abuse is different. It's really not about the care, okay? The patient, the resident, is the plaintiff's attorney's entree into your operation. They're a necessary part of this, but what they're doing is using that plaintiff to get into your system. And the more experienced and the more savvy the plaintiff lawyer, the deeper they're going to dig into your operation. Now, when the legislature said, okay, let's encourage plaintiffs' lawyers to sue on behalf of elderly and dependent adults, there was a lot of pushback, and so the perceived compromise is the legislature says, well, we're going to make it harder for the plaintiffs to prove elder abuse. They have to prove more than mere negligence. They're going to have to, and then there's we have physical abuse, neglect, financial abuse. My focus today is mostly going to be on neglect, okay? Because neglect is the playground. That's the ballpark we're almost always in. It's very, very rare that we see an elder abuse case where a staff member slugged a patient or resident. It happens, but that isn't what we are dealing with when we talk about elder abuse. And I can't tell you how many hundreds of times I've met with leadership of long-term care, leadership of healthcare providers, administrators who say, this is ridiculous. We didn't abuse this person. We took good care of this person. Well, there's very fine definitions here you need to be aware of. But the legislature says, okay, we're not going to just allow claims for negligence. that already exists. It's going to be, they have to prove neglect or abuse. They're going to have to prove some higher level of wrong. It's not just a breach of the standard of care. They have to prove the defendant was reckless, fraudulent, oppressive, or malice, which sounds like a large hurdle, and it is. It is. Again, the playing ground here, where the ballpark is the word recklessness, okay? So our elder abuse claims, 95% are players are focusing on neglect and recklessness. And they recognize they have to prove those things. They have a higher burden of proof, clear and convincing evidence. And when they're suing your entity, they have to prove corporate ratification. Lots of hurdles, right? Lots of hurdles the plaintiffs have to jump over. And that was the intent of the legislature. So who can be a plaintiff, or who can a claim be brought on behalf of? Well, an elder adult is defined as someone 65 years or older, and they have to be in the defendant's care or custody. And there's an evolving case law on what exactly that means, but let's just assume that if someone's admitted or being seen at your hospital and they're over 65, they are under your care or custody, okay? The other area is dependent adult. And so we call it the elder abuse statute. My topic is elder abuse, but I do want you all to understand that there is a whole other world of people that can bring these claims, not just someone that's over 65 years of age. Dependent adult, the definition is here, 18 to 64, has limitations, or who is admitted as an inpatient in a 24-hour health facility. Okay, so basically any resident of a anybody admitted to a hospital over the age of 18 is a dependent adult. They're admitted in an inpatient setting. So it's broad. Honestly, I don't see a whole lot of those claims. It's usually elderly, but I can tell you, and I'll share probably later, one of the biggest settlements to come out of elder abuse litigation that I'm aware of in the last couple of years involved a pregnant woman who clearly was not, elderly, and it was an allegation that stroke wasn't picked up and had serious damages, but it really went south for the hospital, unfortunately. All right. So one of the problems we have is that in defining elder abuse, the legislature and the Judicial Council prepares these form jury instructions. And so what they try to do is take whatever the law is, case law, statutory law, and write it in a way that a jury will understand it and apply it at the end of a trial. So the jury instructions are instructive. At least it tells us we know what a jury is going to be told. And I've put up here the definition of neglect. And the problem we have with neglect is that it is very broad, and arguably neglect could include things that we can't prevent. As you go through the list in the Casey instructions, the jury instructions, it can be malnutrition, dehydration, things that can happen as a natural consequence of disease. So the definition of neglect is very broad, all right? It really is negligence or even less, because it doesn't even contemplate standard of care. Well, but then here we see the jury instructions where the legislature tried to make the hurdles higher. Clear and convincing evidence means a party must persuade you it's highly probable that the fact is true. So there'll always be a claim for negligence in your cases and a claim for elder abuse, and the burden of proof for negligence is a preponderance of the evidence, more likely than not. Then they get the clear and convincing. There's thought that, at that point in time, juries aren't paying a lot of attention to the distinctions between, recklessness or clear and convincing, this highly probable versus more likely than not. But that's our job. That's the defense lawyer's job to argue that and show that that's a giant chasm. The definition of recklessness is also there. Highly probable knew his conduct would cause harm and knowingly disregarded the risk. It's more than a failure to use reasonable care. Again, on the defense side, we think this is very watered down, and we can point to multiple published appellate opinions where recklessness in elder abuse context has much stronger definition. Much more stringent for plaintiffs to prove, and we asked for special jury instructions, but courts will typically default to these Casey instructions. So those are some of the challenges we have, that while the legislature set the bar high, there's a lot of wiggle room in how it's actually presented at trial. So then, in order to hold an organization liable, the plaintiff has to prove ratification, corporate ratification, which sounds and is tough, right? You have let's go to physical abuse. You have a staff member slug a patient. Well, that staff member is acting inappropriately and with an intentional tort, but can that be elder abuse? Can plaintiff prove elder abuse? They're going to have to prove that the management, the managing agent of the entity authorized, ratified, adopted, approved, or personally conducted it. If the president of your hospital did it, well, that's ratification. He or she is the managing agent. So I've got the definitions. I won't go through all of them, but just understand that when we get into discovery, that's going to be a big part of my discussion later on, risk management. The corporate ratification is as much of a shield, making it more difficult for plaintiffs to prove, as it is a sword for the plaintiffs, because when any of you that have been sued for elder abuse by a good lawyer, talk about that in a few minutes, an experienced lawyer, know that discovery is very detailed, very in-depth, goes deep into your organizations. It's very broad, very different than what you see in a typical medical malpractice case. And this managing agent, then the plaintiffs use this managing agent component, ratification, as their sword. They say, look, Judge, we have to prove not only this bad thing happened, but that the hospital or the nursing home or the RCFE-AL approved it, knew about it. A managing agent was involved. So therefore, going back to what I said at the beginning, it's not about the care. They want to get into your budgeting and how you're spending your money and what do you know about complaints in the building and what have you done about complaints and have you ignored them and are the staff asking for more help? Are they being properly trained? And so because the plaintiffs argue, we're entitled, not only are we entitled to this, we have to get this information because we have to determine whether a managing agent ratified the conduct. And so as we get into risk management and managing claims, I want everybody to understand that the rules are different for discovery when you're being sued for elder abuse as opposed to straight medical malpractice. At least they're applied differently very often. All right, so that Delaney versus Baker case, when the Supreme Court looked at this and they said, if a plaintiff proves elder abuse, it's not professional negligence. There is no cap on a living plaintiff's general damages. There's no 250 cap. So if a resident in a nursing home, hospital, which would typically be covered by MICRA, successfully sues your organization, they're still alive, and a jury awards them $1 million for pain and suffering, they're going to get the $1 million under Delaney versus Baker. And so you will find plaintiffs' lawyers that love elder abuse cases with living patients, okay? Because if they can get to a jury, it will open up the cap for them with our healthcare defendants. Also, as a lot of you may know, if it's an elderly person, they're probably entitled to a preference or priority trial date, which means as soon as a motion is granted, we're going to be in trial in about 4 months. We have 4 months to work this case up and be ready for trial. So the sophisticated plaintiff lawyers understand that one way or another, this case is going to be wrapped up fast, and they're hoping they're going to be putting a big check in their pockets, within 6 months of filing the case. When there's a wrongful death medical malpractice lawsuit with no elder abuse claims and nothing, then the pain and suffering of the decedent dies with the decedent, no matter how badly they may have suffered in your hospital or nursing home or even assisted living. The law is that a dead person cannot sue and recover pain and suffering. When there's an elder abuse lawsuit, however, when there's an proven elder abuse claim, then the claim is brought on behalf of the decedent, and the jury is allowed to award that decedent pain and suffering damages. It's the only circumstance I'm aware of where a dead person can be awarded pain and suffering damages. That's the exception, one of the exceptions carved out by by the legislature. That was one of the reasons the legislature perceived that lawsuits weren't being brought on behalf of elderly people because they don't work, so there's no lost earnings. They can't recover for pain and suffering. There's really not any hard damages to bring. So in an elder abuse case, if the plaintiff is alive, there's no cap on general damages. If they're dead, they can recover the general damages for the decedent. That general damage recovery, however, is tied directly to the MICRA statute. So what we, as we say it, pain and suffering damages for a decedent can be recovered if there's a finding of elder abuse, but they are capped at $250,000 because it directly references that section of MICRA. So when we look at when a typical complaint comes in against a nursing home or a hospital, set aside assisted living for a second, we generally think, okay, they can get up to $250,000 for the wrongful death of the decedent. They can get up to $250,000 for the pain and suffering of the decedent, and they can also get, under elder abuse, attorney's fees, okay? And we get into a situation where we have an attorney's fees tail wagging the dog. It can become all about attorney's fees. Legislature says, if you bring, plaintiffs' lawyers, if you bring these lawsuits and you prevail, we're gonna make the defendant pay your attorney's fees. It only goes one way. So kind of really off-the-cuff analysis of an elder abuse case against a hospital or a nursing home, we'll generally say, okay, the exposure is $250,000 for the wrongful death, $250,000 for the elder abuse, and let's say $250,000, $300,000 for the plaintiff's attorney's fees. Now, we go all the way through trial, and their attorney's fees claim is going to be much bigger. I mentioned Lodestar. That's a case and a proposition that allows the plaintiff's lawyers, if they're successful at trial, to go to the court and say, hey, judge, here's our fees were $500,000. That's the time we invested at, and trust me, plaintiff's lawyers charge a lot more per hour than defense lawyers. That's our fee. We charge my senior partner $600 an hour, and I'm $400. So we billed the equivalent, or spent the equivalent amount of time of $500,000 to prosecute this case through trial. But it was a tough case. It was an important case. And under the Lodestar factors, we should get a multiplier on that of times two. So we should get $1 million. And the courts will do that. They will apply multiplier factors. So that makes these cases, these claims, much more risky, much more exposure. All right, I won't read the list, but the typical elder abuse claims in a healthcare setting or any long-term care setting are things that look probably very familiar to you. Falls and fractures are very common. Also, the skin issues, skin injury is a huge one because it happens a lot. It can be unpreventable, and the pictures can be really awful, right? Improper use of restraints. Just when we have someone in a long-term care setting and they're getting worse and worse and worse, failure to thrive can be the basis of a claim. And of course, if licensing comes in and finds some fault, that's a really good chance that you're going to have a possible elder abuse claim. Doesn't mean it's elder abuse, but you might end up having that seeing that in your lawsuit. Talking to my skilled nursing facility participants right now only, there's another claim that can be brought, and it's very challenging for us. It's a very specific claim under the Health and Safety Code, 1430B. And what it does is it's basically designed to be a remedy for someone who claims that their right was violated in a nursing home, okay? It can only be brought against the licensee of a nursing home. And it's designed, someone says, they're not delivering my mail. This statute will allow the resident to bring a claim, recover up to $500 and their attorney's fees, okay? Again, we have the attorney fee tail wagging the dog. The challenge, there's a dispute in the courts right now as to whether it's $500 max for the whole case or $500 for the various claims, and we've got case law all over the place that you can only get $500, and there's a case that approves hundreds of thousands of dollars of recovery for thousands and thousands of violations. And that's yet to be resolved. We don't know where that's all going to come in. But the more important aspect, as we're evaluating our cases, is a recognition that it is extremely easy for a plaintiff to prove a right violation, because the right violations are very broadly defined by the cases, including charting errors have been determined to be right violations, forming the basis of a 1430B claim. And you're not going to find a chart that doesn't have an error, right? So we treat these claims basically as strict liability claims. They're not, but the plaintiff points to a charting, an error in charting, says my rights were violated, give me my $500 and pay my attorney all their fees. And the state of the law right now is, and really in practice I can share with you, I've been an attorney almost 30 years now. When the courts have an opportunity to award attorney's fees, they often do, and they're often generous. So we, as a strategy, again, talking to my nursing home people, as a strategy, we try to shut these 1430B claims down immediately. Our practice has been anything from amending the answer, not contesting 1430B, sending the plaintiff a check for $500, say, what are your fees to date, depending on the circumstances. But there's no resolution on it, but we encourage, and I think as a defense community, encourage our clients to make early gestures to resolve 1430B, because we don't want that coming up in a trial and being the only thing that a plaintiff wins. And there is a case on that point. The defendants, it was nursing home, defensed wrongful death, defensed elder abuse, but the jury found a few hundred charting errors, and it resulted in an award of $750,000 for the charting errors and the attorney's fees. So something to be aware of, something to talk to your defense counsel about and talk about early. So some general risk mitigation strategies I recommend, just without the notion of a claim pending, what can I do right now? We want to be looking at our operational strengths and weaknesses. There's a elder abuse prevention checklist attached to this presentation that's available to you through Optima. I've looked at it. It looks wonderful. I'm going to give you some examples, but review your policies and procedures. I'm going to talk about the challenges that these documents, these important documents, can create for us in litigation. Look at job descriptions, again, and just things that we know a plaintiff lawyer is going to be looking at and trying to use against us ultimately. And most importantly, always emphasizing, I have encouraged New York Times writing and communication, the notion that everything you say, everything that is written, is going to be on the front page of the New York Times. It is, I'm sure you've heard it. I'm going to show you some examples of how very innocent statements can become very problematic. It should just be rote. And if somebody writes something to you, I had a client that loved to write emails and loved to use capital letters to express their frustration, and it just looked terrible. It looked terrible. So as you're communicating with your team, as you're talking to your team, just ask them to be mindful and recognize that at any given time, people are looking at this and evaluating not only them but the organization. So here's the tools that Optima has provided. I have just a screenshot here. I believe they're attachments to the presentation. So policies and procedures. Over the years, if you've been the unfortunate recipient of an elder abuse case from a good, experienced plaintiff lawyer, you've been asked for your policies and procedures. Why? They want to prove that we're not following our policies. Okay? It's really easy and clear. I've had clients that, with the greatest of intentions, they want to distinguish themselves as the best in the business. I'm kind of talking the AL side over there, my AL people. They had these policies and procedures that were extraordinary, and they basically expected perfection. They set the standard for perfection. I, of course, argued it's the gold standard. It's not the standard of care, but they were so aspirational that it really made it hard for the employees to meet their own employers' expectations. Also, this is an example I'm showing you of where we had, one of the cases I tried was a man who supposedly choked in his skilled nursing. He choked on his meal in his bed and died, and it all turned out well for me in the end, but it was a difficult process getting there. There's actually a published opinion on this one. But one of the things that was really startling is how many different policies and procedures applied to this single 2-minute episode, and making it very, very difficult for me to prove that we did everything pursuant to policy, right? I was proving we did things pursuant to custom and practice and standard of care, but policy after policy saying the same things, and sometimes we'll have policies that conflict, with different expectations. I encourage my clients to review their policies and be careful with policies. They're wonderful tools, but I'm a fan of policies that you have to have. You have to have an elder abuse policy. Have it, right? But for practice pointers or expectations, maybe you can have it in a different form. Nursing practices or suggested practices, because what we know is that no policy can contemplate all exceptions. So I encourage my clients to just look at their policies, and the state comes in and they find an error. And so some clients will just immediately draft a new policy. Here's the policy. And now you have another policy in the books. A quick example. My partner is starting trial today on a nursing home case involving a dislodged G-tube. It was a very obese patient who was comatose. Looks like the G-tube was dislodged. The facility had an ancient policy in its books that G-tube placement is supposed to be checked by pH strips. And nobody knew that policy was even in the books. And our experts say that's not the way anybody checks G-tube placement anymore. It's not the standard of practice. But it's in our book. And so it's being used against us on an elder abuse trial. And why was it there? I don't know. Maybe it was, some generic policies they purchased from years ago. Maybe it was responsive to a specific incident that happened. But really use a critical eye towards your policies. Job descriptions. Now, I'm not an employment lawyer, and I know that job descriptions are important from an employment side as well. But I have seen, this is an example, a CNA job description that was 8 pages long, and I just have some of the snippets here, right? And imagine sitting in a deposition next to a CNA who is providing care for the decedent, who uses English as a second language, amazingly wonderful person, but fish out of water in a deposition context, and then an 8-page job, their 8-page job description is put in front of them, and they're questioned about it. Do you do this? Do you do this? Do you do this? This 8-page job description, nobody would be able to do all of the things contemplated in there. It was over-inclusive. It was descriptive and I'm sure carefully drafted, but not with an eye toward how it's going to look in a lawsuit and whether it's really realistic. So I encourage job descriptions that are complete, that are well thought out, that serve all purposes, but they're also practical and realistic. I doubt anyone other than probably the lawyer that wrote this job description ever read the whole thing. I'm picking on lawyers. How about that? Okay, writing for the New York Times. I'll move ahead here, but there's so many writings in a healthcare setting, right? It's not just the chart. It is not just the chart. And when a lot of times we get away in a med-mal case, here's the chart, and that's the end of the inquiry. Those skilled plaintiff lawyers are going to ask for every piece of paper that exists. These notes, 3 of them happen to come off scheduling sheets, okay, where the supervising, the director of staff development is writing a note to the team coming on. I will make rounds, make sure you shave your residents. Please cancel a care provider on the first census. When we're talking about staffing and profits before people, sure, you can, of course you send people home if the census is down or for other reasons, but, if we could avoid writing it and giving it to the plaintiff lawyer and being blown up as an exhibit, that would be nice. Over here, dress your residents in Christmas-appropriate attire, not Halloween clothing. Today there's a Christmas party at 6. It's a very good, oral instruction, but I'm sure they never expected to see this in a trial, but it was. Here's a really good one. Down at the bottom, this was a part of, I believe, in-service training. Many residents had fallen out of their beds or their wheelchairs, so please always visually check assigned residents for safety precautions. Not helpful in a fall case particularly, right? Not helpful in any case. So how we are saying things, what we're writing down is important. So some proactive steps pre-litigation. I'm kind of contemplating a difficult family or a difficult circumstance. Try to always be pragmatic and realistic in your interactions with the family. Don't overpromise. Be responsive. Sometimes it's so hard to pick up that phone when you know you're going to get chewed out, but if you don't pick up the phone, it could be a lot worse. Make sure here you are documenting efforts that you're making to resolve problems and what the reaction is to it, okay? We want to be able to show, look, if a jury likes you and a jury respects you and a jury believes you, they're probably not going to find elder abuse. So they may, it could be, this could be a really, we blew it type of situation. But if we're trying to make it right and we can show we're trying to make it right, it's going to be hard for a jury to find that we were reckless and the conduct was, ratified. These actually are specific strategies that can disprove ratification, and as well as taking proper response when, for example, one of your employees does haul off and slug one of your residents or patients. Be proactive. Make sure that you're preserving that information that we'll need. Whether it's witness statements or photos, videos. Now today, if you get sued and I happen to be assigned as your defense lawyer, you're immediately going to get from me and my team a letter. It's an evidence preservation letter. and it is critically important that any videos, from the hallways, the parking lot, any photos, they must be preserved. If they're not, there can be serious evidentiary consequences. A lot of you, this is preaching to the choir, don't hesitate to involve legal or risk management staff, and it is okay to say sorry when it's appropriate, and I provided you the California Evidence Code that talks about that. I was listening to a podcast of the chairman of the board of Disney, and he was being interviewed by Oprah. And he, in his book and in his podcast, he was talking about that horrible situation a couple years ago when the young boy was attacked by the gator. And he says, the first thing I wanted to do was reach out to this family. And Oprah says, well, the lawyers don't ever want you to do that. And I turned to my wife and said, that's not true. We're not horrible people, And he did reach out to the family. And, of course, there was no lawsuit. That thing settled immediately. But it's okay to apologize. It's just who does it, what is said, and what the context is. So I provided the evidence code saying we're so sorry for your loss, we are sorry for your pain. This evidence code says it's not admissible, okay? They can't reference it at trial. Now, if you say, this was our fault, I'm so sorry, well, that is an admission. So it has to be carefully delivered, but it is okay to say we're sorry. So I like to find, when I get called about this, who has a relationship with the family. It may not be the CEO. It could be the charge nurse or there's a lot of things that can go into it. Maybe somebody has an outside relationship with them. Get the right person and formulate how are we going to do this and what is going to be said. And if you can't be sincere, then don't do it, right? And also, can we help with, we're so sorry for your loss. Can we help you with some of the expenses? That's appropriate too and not admissible. Okay, the claim comes in. All those pre-claim efforts didn't work. Number one issue, and I've referenced this, who is suing you? Who's the plaintiff lawyer? I can promise you, after doing elder abuse work for over 20 years, the only thing I really need to know is who's the lawyer, and I will be able to pretty much lay out for you exactly how your case is going to proceed. If you are being sued by what I'll call an A player, an elder abuse litigator, that's what they do. They don't do anything else or very little else. And they're aggressive. It's somebody I'm almost sure I know. It's going to be a battle. And we need to talk about strategies and how we're going to, what's coming and how we're going to address it. There might be a lawyer who only does medical malpractice and they happen to get an elder abuse case. That's going to be handled differently. It could be very difficult too. I get great plaintiff lawyers, really accomplished plaintiff lawyers, wading into elder abuse, thinking they've got, the best case they've ever seen, and there's a lot of work in educating them that it's not a great case. So, of course, once we know who the plaintiff lawyer is, we're going to be looking at what the issues are: fall, skin breakdown, failure to thrive, wandering. We need to know that. And the causes of action, of course. We always, in my world, we have corporate parents and subsidiaries and DBAs, management companies, and so it's best to sort out early exactly who the players are, what their relationships are, and what role each plays or doesn't play in delivering care. If there's a holding company that the name is plastered over everything, but has nothing to do, basically has no employees and nothing to do with care, your lawyers need to know that right away. No guarantees that we're going to get anybody out, any entity out, but we need to know right away who's responsible for what. Where the venue is important. My friends on the call that are in Northern California, cases have more value up there. I can't tell you why, but the verdicts are higher and the settlements are higher. Down in Southern California, and that's true with my partners up in Northern California as well, but in Southern California, we've been able to kind of maintain those values. I won't say better. We've just had more success in keeping them down. Not to say that they're cheap by any stretch of the imagination. Arbitration is really, really important when there's an elder abuse claim. And we typically try to enforce those arbitration agreements because we believe, when I was an only med-mal defense lawyer, the last thing I wanted was an arbitration. I knew I had a probably 85–90% chance of winning at trial because juries like my clients, and I've got great experts, and the guy being sued is or the hospital, they're well respected. I don't want arbitration where they're going to split the baby. Well, I then go defending long-term care and elder abuse cases, and I'm more than happy to split the baby. We can win them, and I've had arbitrators grant summary judgment motions, get rid of elder abuse cases. So we feel like we have a much better shot at winning, or at least really maintaining the exposure in an arbitration. They can be very hard to enforce. I won't go into the details, but here's the key. Let your defense lawyer know if there is a signed arbitration agreement, and then you can make the decision of whether it's enforceable, whether you want to try and enforce it. And priority setting I talked about earlier, that's critical. Once that motion is granted, you are just on this sprint to the finish line. Secure everything. You've already all know an altered chart is just not defensible. We can defend almost anything, but not an altered chart. And the lawyers that when we're using the EMR, the audit trails are being requested, and that's a whole new world. But we need to secure it. It's part of that letter you'll get. Make sure everything is collected and secured. We don't want gossip, but if a particular staff is implicated, they probably should be made aware. A lot of plaintiffs' lawyers will ask for the roster of all employees, right? And particularly former employees, and they're going to be reaching out to these former employees and tell me how crappy this job was. So it was horrible, wasn't it? You didn't get any support. So we need to be proactive in trying to get what I call getting people under the tent. Making sure that people aren't aligning themselves with the plaintiff lawyer, particularly without intent. They don't know it, and the next thing you know, they're a star witness. Early investigation, you all know this, is really critically important. Get in early, understand the facts, who's involved, where's the exposure, what experts are we going to need. Early workup and early experts are usually very helpful. We have to tell our story. So I like to know, did anybody bond with his family? Did anybody spend extra time? I've called volunteers that worked in nursing homes as witnesses. Members of the clergy have been witnesses for me. Help us tell the entire story. A lot of elder abuse is defense. We're just playing defense. And the more offense we can play, not necessarily going after the family, there's not a lot there, but what else can we find to help us tell our story of who we are? Photos and thank you notes, those longer-term residents, but that happens in acute hospitals a lot, right? You get a thank you note, you get a card. It probably isn't a bad idea to scan those in and put them in the chart. I had one case real quick, nasty elder abuse case, top-notch plaintiff firm. Woman had been in the nursing home for years, and well into the litigation, my clients fax me, and this is, tells you the technology, a copy of the woman's obituary where the family thanked the staff of my client nursing home for all the care they delivered over the years. Critical evidence, so important. It's so hard to find. And that's the V8 moment. You know, it's kind of dated because they don't have the V8 commercials anymore. I could have had a V8 slap in the forehead. We need to know early who can help us. I can't tell you how many times I've been getting ready for trial and someone will say, you know who you should talk to? You should talk to Bob in dietary because Bob, you know, he was preparing special meals and he, well, you know, that's too late. So we need to know that stuff up front. So themes, you know, this is telling us what this next slide, they're going to be going after record keeping. They want to know about our prior incidents and whether we've been responsive, our DPH history. Folks, when you get sued for elder abuse, you got to choose your battles, okay? There needs to be a recognition that the plaintiffs are probably going to get a lot more discovery and get much further into our operations than they otherwise would have in a straight med mal for the reasons I've talked about. And where I've seen problems is when particularly acute hospitals, but this is, you know, skilled and assisted living, saying, I've never had to produce this in my life. There's no way they're going to get this information. You tell them to pound sand. And next thing you know, the court's granted a motion and issued sanctions. And that big case I mentioned with the woman that stroked, the reason, the fix was in, and I'm not criticizing anyone, but ultimately a discovery referee recommended that the hospital receive evidentiary sanctions, striking an answer. They could not defend the elder abuse claim because the discovery referee perceived that the hospital was not being compliant in discovery. So hopefully you're working with defense counsel that's skilled, that's been down this path many times and can advise you on, you know, where to fight the fights. And, you know, if I kind of take the position, if it's not going to hurt us, you know, that's probably not something we want to fight too hard about. We get portrayed in court, and this is true with acutes, although, you know, the acute hospitals have a lot going for them in terms of more staff, better educated staff, better documentation. So let's use that to our advantage and not make the judge think we're trying to hide something. So the hurdles that we run into, former employees can be just terribly problematic for us. It's sort of the plaintiff's bread and butter. And so we need to know, I'll usually ask, hey, are you aware of anyone that might be particularly problematic, was involved in this person's care? We need to find out if we can get them under the tent or whether we need to start developing strategies to deal with that person. I talk about care model and staffing. Our staffing levels are lower, appropriately so in a skilled nursing setting rather than acute. But recall that at least for skilled nursing facilities, OBRA requires sufficient staff to meet the needs of the residents. So in our skilled setting, there's never enough staff. According to the plaintiffs, it's self-fulfilling. If you had more staff, this bad thing wouldn't have happened to our patient. And so we usually find our defense in the medicine on those. Record issues are unsophisticated witnesses, compliance issues, and that can be compliance with regulations, with policies and procedures, job duties, and some of the preconceptions, particularly as we get into skilled nursing, what people think about nursing homes. So those are challenges. Reptilian theory is a approach that plaintiffs' lawyers use about going towards the jurors' basic instincts of being safe. And they try to make it, it's improper, but they work around, they try to work around that this could happen to you. You can't allow this to happen. That they would never be allowed to say that, but those would be the themes. Do you want this happening to your mother, to your father, to your loved one? Defense lawyers are going to know how to deal with those things. So here's a common list of things that are asked for in discovery. Know it's coming. Figure out with your defense counsel where to battle. But don't cross your arms and say they'll never get this, we've never had to do this. It's a different claim. It's a different proof. And I've been through it, the ringer, for 2 decades at least, trying to fight these battles. More often than not, judges are going to err on the side of give them the information. I can preclude it later at trial, give it, unless there's a really good reason not to. The plaintiffs way more often than not are going to get what they want. Quick evaluation, expert reviews, those themes. I'm such a fan of themes and safe harbors with our wonderful staff that use English as a second language, that there's such a foreign environment being in deposition. I like to give them places to go with their testimony and their answers. I did the best I could. We work hard for our residents. Whatever those themes are, they really can be empowering for those witnesses and helpful for the defense. I'm a big fan also, folks, of trying to resolve cases early. Elder abuse is going to cost you money. It's going to cost money to defend. There's tons of time involved. It's very invasive in your operation. There are a lot of costs that beyond money when you're being sued for elder abuse. So I'm always looking where is the best outcome. I talk about mitigating losses. I tell clients that once you're sued for elder abuse, you can't win in the purest sense of that word, okay? Because of those costs that you're sure to incur. Money, time, interference with operations, looking for records, all of those things. So I'm about what's the best outcome, and sometimes it's trial. Sometimes there's just no other alternative. But oftentimes we can mitigate our losses and get these cases resolved and move on. Try not to get angry. At least don't, understand. One of the things I keep in mind when I defend an elder abuse case is that the people that are suing us have probably gone through some of the worst experiences of their life. Losing a loved one is terrible, and particularly with some of the diseases of aging, it can be cruel. And so, I recognize that and understand that they're angry. And the whole process of defending the case is to validate that. They're entitled to be angry. It's terrible what they've endured, but their anger is misdirected. And we have to develop a defense that allows us to show where the anger is properly directed, understanding you have a very good plaintiff lawyer trying to point it directly at us. Present a caring face. We must be trustworthy. We cannot win these cases if a jury doesn't trust us. Altered record, caught in lies, that will be our doom. I tell every witness I represent, you must tell the truth. All right? We start with that premise. But that doesn't mean we have to fillet ourselves and lay our guts out on the table, right? So the truth is, in these instances, is very, it can be difficult to get to. And so we work with our witnesses on that. When we get a jury educated about who we are and what we do, we almost always get a good result. I like to start with the premise when I defend particularly nursing homes, let the jury think we're crappy, because we're not. And I figure it's much easier to meet low expectations than high expectations. I've butted heads with clients over this over the years, you know. But what I'm going to show the jury is extraordinary, what we actually do for people, the level of care that we provide. So, you know, to some extent, let's find those, how we can make these things work for us. All right, folks, that's my presentation. I am available to answer questions. I think I've pretty much used up my hour, but Millie, if there's any questions, I have no place to go, and I'm more than happy to address anything anybody would like to talk about.
Okay, thank you. That's so much really good information. A question did come in. I think it was back on slide 8 when you were talking about enhanced remedies through the chat box. It says, as a result of potential financial exposure, do you see a higher percentage of settlements out of court, and what do they usually settle for?
Okay, the first part of that question is yes. Not only the financial exposure, but as I also talked about, the time, the invasiveness, the morality. You know, some of these employees get beat up. The worst thing I think can happen is somebody quits, a good care provider quits because they don't want to be, you know, treated the way they get treated. What do they settle for? You know, you need to tell me, number one, who is the plaintiff lawyer? It's frustrating, I know, but I've settled this past month, different context. I settled similar cases for $75,000 and several $million because of who was on the other side of the lawsuit. That was not elder abuse, and the disparity isn't quite that big, but who is suing you is a tremendous driver, because those top-notch plaintiff lawyers can run your costs through the roof, and so, you know, just a recognition of that. Now, a plaintiff lawyer that's not real familiar with elder abuse and has just tagged it in there, we're gonna really beat the you know what out of those people, and there isn't going to be a premium on the settlement. So I can't tell you how much they settle for. I can tell you that who's suing you is going to be a real big influence factor on that.
Okay, thank you. Do we have any other questions? You could press #6 if you just want to unmute your line and ask it over the phone, or you can chat one in. While we're waiting to see that, I do want to point out the Elder Abuse Leadership Tool and evaluation in the lower right-hand corner. There's direct links to that, and of course you will have access to those through on the handouts and online in the resources. I'm not hearing any questions right now, so if you think of any, send them my way. And Brian, thank you so much for this information. It was really, really good and very valuable. I appreciate your time and all of our participants. Do you have anything to say closing, Brian?
You know, we're here for you, and I want you all to know that I spend a lot of time just helping, and me and my partners, we're part of this industry as far as we're concerned, and always happy to take a call, always happy to give some thought and some advice. Millie, you know how to get a hold of me. Don't hesitate to call. We're here for you.
Okay, thank you.
All right.
Everybody,
Okay.
have a great day today, and I'll close the meeting now. Bye.
Great. Bye-bye.